Good morning. I'm Meg France. I'm a water resources engineer with the environmental consulting firm Brown & Caldwell. I've spent my career working on surface water modeling, consumptive use modeling, a little bit of groundwater modeling, but enough to have a significant interest in the topic that's in front of us this morning, which is science in the water courtroom, or more broadly, in water law. I want to thank the symposium for inviting me to moderate this panel, as I'm honored to be in the company of the distinguished guests that we have, and I've enjoyed getting to know them a little bit as we've gotten ready for this panel. The way it's going to work, I'm going to introduce the three speakers. They're each going to give you their reflections on the business of science, data, mathematical modeling in water law. And then I'll ask maybe a couple of questions on themes that I've heard, and I want you all to be thinking about what questions you'd like to ask. I know we have inquisitive minds here. I was going to ask people to step forward to the microphones to ask their questions, but in the last panel I thought it worked pretty well with people just sitting at their seat, and that's maybe a little less awkward. I just ask everybody to speak from the gut and speak clearly so that everyone in the room gets the chance to hear your question. So all of the experts that we have this morning are experts in their fields and represent a diversity of perspectives. They're also just plain solid citizens, as evidenced by the fact that they're willing to spend their morning with us and share their knowledge. Our first guest is Chris Sanchez. Chris is a hydrogeologist and a principal with Bishop Brogdon Associates. His interest and experiences in water supply, investigations and planning, wellfield design and implementation, geologic analysis, groundwater modeling, and application of all of the above to water rights. Chris has testified in Water Court in Division 1 and also provided expert testimony in hearings before the state engineer on produced non-tributary groundwater rules and before the Colorado Oil and Gas Commission regarding monitoring and sampling rules. I can't resist adding that in the last year of my 5-year tenure with Bishop Brogdon Associates, I won't say how long ago, I met Chris as our summer intern out of the Colorado College Geology program. So, has he grown up? I'm going to go ahead and introduce everybody and then we'll start the... Next we have Dick Wolf, who truly needs no introduction in a room full of water professionals in Colorado. Dick has served Colorado as its state engineer for the last 10 years. Trained as an ag engineer at CSU, Dick began his career in private consulting with Spronkwater. And then he heard the call to public service. And this has been a theme in his life and in different places, in different outlets. He served on the city council of the town of Fort Lupton and as their mayor early on. He spent 10 years serving on the advisory board to Colorado State University's Civil and Environmental Engineering Department. And he's currently serving on the advisory board of the DU Water Law Review. Dick began his professional public servant life in 1993, hired in the Division of Water Resources, and worked his way through the ranks until his appointment to the state engineer's position in 2007 by then Governor Bill Ritter. As state engineer, Dick heads a staff of nearly 300 people and manages a budget of $25 million. His division includes the Office of Dam Safety. He oversees groundwater well permitting, manages collection and dissemination of gauge and diversion data, and all of that in addition to administering Colorado's water rights in accordance with the Constitution, statute, and 5 interstate compacts. So thank you so much for joining us, Dick. And finally, I want to welcome Dr. Burke Griggs. You heard his bio introduction before, so I won't run through it again, except to point out that in his service in the Attorney General's office in Kansas, he represented Kansas in the action against Nebraska to enforce the Republican River Compact and to work through compliance issues, and of course, at that point, crossed paths with Dick Wolf.
And he's still my buddy.
So, Dr. Burke has since returned to academia since his days in the Attorney General's office, and in the current academic year joined Washburn University's law faculty. His research explores the themes of property right regimes and natural resources, how natural resources respond to different forms of ownership and exploitation, and the political cultures of owners and communities that are sharing natural resources. So welcome back to Colorado, Dr. Griggs. Chris?
Thank you, Meg, and thank you for being an excellent mentor all those years ago. It's fun to be here as the first technical or non-legal person here addressing you today. The role that we get to play as on the engineering or technical end is fun in that we address a lot of technical issues, but we are not the legal experts. We work hand in hand with many of the excellent attorneys in the room here today on the technical side, and through that process we become quite entrenched in the world of water law, but we get to fill the void on the technical side. There's various issues and technical questions that we get to work through in the work that we do, including surface water impacts and a variety of groundwater concerns. But what I want to chat about today is some of the issues related to groundwater surface water interaction, because I believe that provides some particularly interesting issues that come up in a courtroom environment. And part of that process, we sometimes struggle with a lot of unknowns, a lot of lacking information. Groundwater is a little bit enigmatic. There's the world of surface water. You can go out, measure flows in a head gate. You can measure what is and is not present and how much someone is diverting, and impacts are fairly quantifiable. The world of groundwater, especially when we're dealing with issues such as groundwater, surface water interaction, it's a lot more difficult to quantify impacts, and there's a lot more professional judgment that we have to rely upon in order to get to the information that we need. Then finally, at the end of the presentation, I'll comment on just some of the court processes and some of the incentives for scientific processes that we run into, and issues related to communication and culture and some of the fun that we get to have in that regard through the work that we do. First of all, with respect to groundwater surface water interaction issues, keep in mind that groundwater moves very slowly. There's the aquifers that we deal with in the state of Colorado are varied. Some are shallow, some are deep, some are very deep, and some are more connected to stream systems than others. Quite frequently, we're addressing the interaction, the impacts that occur in an aquifer system when you pump a well, and how, when you operate that well, how does that impact a stream? A lot of times those impacts occur days after that well operates. Sometimes it's months, years, and sometimes millennia. And part of the aspect that we get to quantify is just how does that interaction occur, and where and when. The concept of non-tributary groundwater is very important in that non-tributary water is classified as water that's effectively separated from the surface water system. That's important because once you achieve that designation, that water is effectively removed from the prior appropriation system. It is effectively no longer administered as a priority water right. We get involved frequently with water that's being classified as non-tributary, both on the applicant and the opposer end. And in a nutshell, it's important to get those findings right. What is that non-tributary standard? Let's chat about that briefly. A depletion rate of 0.1% after 100 years of pumping is what's required to achieve a non-tributary standard. That's a tough standard in Colorado. And it needs to be supported with solid evidence. To achieve that standard, which effectively entails removing that water from the priority system, it needs to be proven within, let's see if I get the terminology right here, not just based on the preponderance of an evidence, but clear and convincing standard. Thank you, Dick. That's an important distinction, because there's many situations in which, for the purposes of administering an augmentation plan, you might be able to stick with the standard of just preponderance of the evidence. The data suggests that this is the timing relationship between pumping a well and the impact of the stream. But when you have to transition to clear and convincing evidence in order to demonstrate non-tributary standard, it's just that, it's clear and convincing. And sometimes we run into situations where we might argue, no, that standard has not necessarily been met. Something I want to point out on this diagram is we may have a well shown that it meets the non-tributary standard. It's fairly logical to conclude, based on the proximity of this well to the stream system, that if that well is non-tributary, wells that are farther removed from that stream system would also be non-tributary in this aquifer system. So we want to point that out as we progress in the conversation, but also point out some of the important things that control this timing relationship. The groundwater surface water interaction is controlled by properties of that aquifer system. What is the hydraulic conductivity of that aquifer system? Are there clay layers that separate the deeper aquifer system from the shallow system? What is the aquifer storativity? All these issues are very important assumptions. In many times, these aquifers that we deal with in the state are well developed. There are many wells constructed. There's a lot of pumping test data available to us. Sometimes we have core data. Systems that are heavily relied upon tend to have a lot of data associated with them. However, there are times when there are large regional aquifer systems that are not that way. They might be relatively new systems that don't have too many wells completed in them, and we don't really have the information at hand to effectively characterize and classify these systems. An example is the Upper Pier Aquifer, more or less in Weld County and pretty much spread across the northeastern portion of Colorado. We've been involved with some situations in which relatively small landowners in some cases, and large landowners, have sought non-tributary claims for the Upper Pier beneath their properties. And that's fine. Those applicants can go through that process and try to demonstrate that. But one thing that's important to recognize is that in a situation like this where you don't have much data at hand, it's more difficult to say with reliability that a system, to characterize that interaction, to say that a system is or is not non-tributary. There's also an important precedent at hand. We might have a relatively small landowner with, say, a small ranch property going through this process, but when they're going through that, there's an implication, or one might conclude that those lands beyond that property would also be non-tributary because of where they're located relative to the stream. In this situation, if we just take this land area, which we've identified based on those that are buffered from, say, a 13-mile distance from points of connection with the stream system, the water that's in storage in that upper aquifer system could be on the order of, say, no joke, like 96 million acre feet. That's about 3 times the full capacity of Lake Powell. That's, on paper, a very large quantity of water, and that's one of the reasons that we work hard to make sure that these findings, when they come across, are correct and accurate, because that's a big chunk of water in the state of Colorado that could effectively be removed from the prior appropriation system. Some of the input parameters include aquifer properties such as hydraulic conductivity and storativity. Like I talked about, locations where the aquifer is or is not under confined or unconfined conditions. It's important to get these factors right. because when you consider the sensitivity of the timing analysis, they could greatly skew the results. Sometimes one of the things that we work on is sensitivity analyses in which we compare different inputs for groundwater models. The magical point in this graph is down here at the bottom. Some of the lines that are flatter and do not cross this line would meet that non-tributary standard. The x-axis is a 100-year time scale. The y-axis is the non-tributary depletion. And just by playing with different aquifer properties, these systems may or may not prevail. Briefly, because I'm running out of time here, there are different model types. There are more sophisticated models such as ModFlow that has been mentioned here. Burke had mentioned that. In our experience, something that we've seen is the difficulty involved when you're in an applicant and objector scenario of trying to defend a ModFlow model. There are many inputs that go into ModFlow models compared to more simplistic techniques such as Glover inputs. And we as testifying experts have the burden of carrying forth the best scientific methods to prove these things up. But one of the challenges that we run into is that when you bring a tool such as ModFlow to the table, it's a lot harder to defend. And however you look at it, there's an incentive to use a more simplistic tool, a less robust tool at times. But again, ModFlow is an important tool, and these things need to be considered on a case-by-case basis. Just briefly, running out of time, but wanted to comment on some of the communication and cultural issues that we get to run into doing the work that we do. One of the parts that I enjoy about the job is just communicating the technical work that we do in the form of reports to skilled attorneys, other consultants that provide the level of detail that is necessary to defend the work to hold up in a court environment. But advancing from that very important process of the work that we do, there's also testimony in front of, say, informed and very educated water judges or hearing officers, and sometimes less informed, but also juries. And it might be a guy wearing a Bart Simpson t-shirt sitting there looking at you with a blank stare trying to understand some of these technical concepts that you're working through. It's, I think, a fun challenge that all of us get to address in the work that we do, both on the legal and technical side. But some communication of some of these technical concepts is one of the things that keeps the job fun and interesting in a court environment. Thank you.
Well, good morning, everyone, and thanks, Meg, for the great introduction. And it's an honor, really, to serve on this panel with Chris and Burke. And I've appreciated working with Chris over the years in his consulting role and always bringing the best science to the game and helping the court and others understand a very complex subject in terms of groundwater modeling. And Burke, what can I say? I've worked with Burke for a long time, sometimes on opposite sides, but he's probably one of the people, if you ever want to have somebody cross-examine you, he's the best one to do it because he's the nicest one I've ever had cross-examine me, and so it makes.
I didn't get anything.
I think he was trying to suck me into like being so nice that I was going to reveal some secret, but no, it's really been a pleasure working with Burke over the years, and congratulations on your role now as professor. And I always seem to see it in his cards because he was so professor-like in his cross-examination, so I knew that was in the cards someday. So it's great to have you in that role now. So I appreciated Chris having this kind of initial introduction, talking about the complexity of the models and the role in the water court. I wanted to kind of touch on a little bit of my perspective as an administrative agent and my role, particularly as state engineer the last 10 years, and the use of groundwater models in particular in both intrastate and interstate matters and issues. And certainly want to point out that not all of the things you've heard this morning talking about a lot of times when we're talking about litigation and controversy and conflicts and having to develop models is a result of some litigation that's out there or complaint and lawsuit that's been filed. But we do develop models, particularly at the state level in Division I resources for other purposes, and I wanted to touch on that because certainly we recognize the importance of those models, and litigation is not certainly a substitute for sound science and facts, but certainly we've heard that the law is there and litigation ensues if we don't have good models in place, we don't have good science and facts to work with. So, but you know, when we think about the other role that models have played, certainly from our standpoint in this rulemaking, and it's not that when we've been through the rulemaking and use of groundwater models in particular that they haven't been challenged. They have been challenged, but because they've had a lot of work and development in them, they've done well in testing through the litigation. But I remember one of our experts when we were testifying one of our bases for our models several years ago, when the judge asked him, "Is are these models accurate?" When you're thinking about, they're trying to give you a perspective of what reality is like underground, and his response was, "Well, all models are wrong, but some of them are useful." And that's really true in terms of what we do. We really want to remember that we can't let perfection be the enemy of good, and so we're going to really, in our role of developing rulemaking and the use of groundwater models, it's very important. We think about this tactically, that we can't manage what we don't measure, or at least to estimate to the best of our abilities with these groundwater flow models. And Chris talked about that and the challenges we have in that regard. The water users out there want and demand this regulatory certainty, and so we oftentimes have to develop rules for that, and these groundwater models can be very important as part of that. So these models in developing the rules have allowed us to develop operational plans and accounting that's been used in many parts of the state. And so I wanted to touch on those just real quick in 3 areas where we've used groundwater models. The irrigation improvement rules in Water Division 2 in the Arkansas River Basin. These cover the irrigation improvements for surface water irrigation systems. So we developed these rules proactively to avoid a potential violation of the Arkansas River Compact. So we developed a spreadsheet model based on the HI model that was used as part of the litigation between Kansas and Colorado. Kind of ironically now that we're using that model to help us avoid getting into another lawsuit in terms of developing the rules, but they were very effective in helping us develop those rules in the Arkansas River Basin. Likewise, in the Republican River Basin, we've been developing compact compliance rules. This is something that I've been currently working on the past year to essentially enshrine the current administration for our compact compliance that's actually resulted from some of the litigation that started in 1998, a lawsuit that was filed by Kansas against Nebraska and Colorado. And lastly, a groundwater model, our Rio Grande Decision Support System model, has been very useful in developing rules within the Rio Grande Basin, starting with the confined aquifer new use rules in 2004 by my predecessor, Hal Simpson, but most recently in our groundwater use rules that we've been working on, started about 7-8 years ago, that I submitted to the Water Court in 2016. So that's going to be, those rules are really used for developing administration for approximately 6,000 large capacity wells. And that model that started the development of that in 1998 has been instrumental in those efforts. We're currently working on phase 7 of that model, and so it just recognizes the long time and money that it takes to develop those. I wanted to touch on just a little bit of some of the pros and cons of using these complex models. Chris touched on some of these, but as we know, that developing these complex models are data and human resource intensive, and so oftentimes they're not always available to, particularly when you're in litigation in a very acute situation. They do develop over a long time. The state oftentimes, in our capacity as administrator, take that role on in developing these complex models with the funding from the legislature, obviously, to make that happen. And we think that these models, particularly the long period we've been working on, like the Rio Grande Decision Support System, they've been developed through a consensus. We look a lot at the science and the facts and the data to get there. And as we've indicated, we can certainly develop these rules without the threat of litigation or as a result of a lawsuit that's been filed against us. So if we do a lot of that early on collaboration and cooperation with the stakeholders out there, the technical experts, bringing all those people to the table, it's been very helpful in setting that up. utilizing these peer review teams that we've had with the Rio Grande Decision Support System has really been effective in getting those models as robust as we can. And we tend to use those models, those very complex models, on a basin-wide, but they can, through these efforts, be used for a platform for some more refined regional models where people want to focus in on a more localized basis, and they've been useful for that as well. Lastly, I just wanted to touch on the use of models and using sound science in the development of laws that are really based on this scientific reality. Sometimes we see these laws reach the legislature based on sound science, and yet a particular interest group or groups may try to obfuscate the true science behind the proposal, which oftentimes leads to an absurd law, frankly, that's been out there. And so I think it's very important that we work early on developing these sound models based on science and reality. I think it really will help us towards that goal of having good laws. And we had, when we look back at our early laws in Colorado in the 50s and 60s, even though there was some scientific evaluation done then, certainly our understanding of the physical system and science has evolved since that time. And so we oftentimes have this thing where the laws are implemented before we have this really fully understanding of the laws. And so I encourage you as coming out, particularly the young students and law students, as you get out to advise clients, or you may become part of the legislative process, helping folks draft legislation, keep that in mind how important it is to make sure that those who are involved in that decision-making process or developing laws take the time to make sure that it's based on good science and reality, because our laws have really got to enshrine that management system we have here that we've been developing since statehood. It's very important for, we talked about, I know a lot of folks talked about where the future goes. From our standpoint, we've got to create the sustainability resources. We've had this continued conflict between surface water and groundwater. Some of that's been a result of not having those good laws in place before we have a good understanding of the science. So, and why I think that's all important, because we don't have those proper laws in place. A man with water has many problems. A man without water only has one problem. Thank you.
Well, you've heard me speak too much already today. I just want to touch on 5 general points, and I'm in a room full of Colorado law students and Colorado lawyers. So my hope is to ask some questions out there, or some very brief observations that you may be able to comment on, because we're in Denver, okay? First anecdote is that the first day of trial when we were suing Nebraska in 2012, Nebraska laid 17 Daubert motions on us to exclude all of our expert witnesses. And you should have filmed the way Special Master Kayada dealt with these Daubert motions. To call it economical or efficient would be an understatement. Okay, Counselor, same arguments as your last motion? Anything from Kansas? Anything from the United States? That motion is denied. Moving on, motion number 14. And then the trial started. We had to deal with these Daubert motions, okay? Which are fairly common in a lot of litigation that involves experts. That's Special Master Kayada, who's now a Court of Appeals judge in the First Circuit. The Florida v. Georgia case that came out just in February, Special Master Lancaster, same firm, right? Who would think that a law firm in Portland, Maine, those are probably some of the most powerful water lawyers in the United States. They just continue to get picked for special master gigs. Meanwhile, certain people get completely ignored. All right. Maybe you could hear a Delaware case. Be completely recused west of the Missouri. But this raises the general issue of modeling in the courtroom, right? It's a battle of the experts. And thousands of articles have been written on that. What I would like to throw out there is, it's not just Kansas versus Nebraska, or Arizona v. California, or Texas v. New Mexico, modeling seepage from Elephant Butte Reservoir, these sorts of things. There's also something that's really interesting, and that is cultural differences about the professions. one of the great privileges of being a part of the interstate lawsuit is you get to work with really impressive experts for a long period of time. And modelers have their own professional culture. Water resources engineers have their own professional culture. They're engineers. My dear client, David Barfield, in the back, he's an engineer's engineer. Okay? Lawyers, some engineers would say we're a little sloppier. We're a little more comfortable with things that engineers aren't comfortable with. You know? And engineers sometimes are trying to outrun the bear. Lawyers are just trying to outrun the other lawyers. If the bear eats the other lawyer, we win. We don't have to be fast as a bear. So I'm throwing this out as a practice point for you, rising law students, that one of the really interesting things about natural resources law is negotiating these cultural differences across the professions, even within your own team. So that's a point I'd like to just throw out there. Another thing is a Colorado procedural rule, which I think pretty highly of, but then again, I don't practice in this state. And that's something Dan Lukey has talked about, and that is the requirement that the experts be on a panel together and that the judge ask them questions at the same time to get away from the game of a cross-examination. Okay? If you think you're going to successfully cross-examine an expert witness when David Robbins is that guy's lawyer, you're dreaming. Okay? Same way, the other giants of the Colorado water bar, and there are too many to mention. Bill Paddock. Someone who's been very helpful to me. Okay? So I'd like to just throw that out there to the extent that procedurally you put the experts from the competing parties in the same table and they can be examined by the judge or by the magistrate. The fourth point is something I touched on in my interstate talk, and that is federal-state cooperation on modeling. One of the reasons Kansas and Nebraska were able to settle that case so expeditiously in 1998 to 2002 is the United States Geological Survey helped them with their mod flow model. The Mississippi v. Tennessee litigation I referred to, that's federally funded groundwater analysis of the highest order. A really impressive national effort to model that aquifer. Western water managers, like state engineers like David Barfield, or the victim of my apparently completely toothless cross-examinations, Dick Wolf, they've been dealing with climate change for a generation now. They've been dealing with changes in precipitation patterns for a generation now. They've been dealing with the consequences of dust in Arizona, getting into snowpack in the San Juans, creating earlier runoff events on the Animas River since the 80s. We have an administration that's cutting back on science. We have a president who doesn't think his hairspray affects the atmosphere because his skyscrapers are airtight. That's a quote. Okay? And he's going to cut back on science funding. Well, federal science funding and federal technology funding is what gave us a lot of fracking technology in the 70s, the Department of Energy. Federal science funding is what allowed a lot of these modeling analyses to take place. Without federal support, these multi-million-dollar modeling efforts, okay, assume Kansas v. Nebraska without federal modeling support. You might have the scorched earth that you had in Kansas v. Colorado with almost 300 days of trial. So, are we going to have support? Okay, another great Colorado water lawyer, Ann Castle, is Assistant Secretary for Water and Science at the Department of Interior, pushing all sorts of climate change initiatives there. How is that going to affect the cooperative federalism upon which so much Western water law is built? Final point, and I'll try not to be sappy here, is one of the really cool things about practicing water law is you are playing the long game. This is something one of our chief experts, Steve Larson, brilliant groundwater modeler, said you're always playing the long game. What you say to Nebraska in 1998 will come back to bite you in 2017 if you don't get this right. Okay, it's part of the accumulated transcripts and exhibits of any long-term water relationship. And I think that affects the way water lawyers practice. They know they're going to have to see Dick next month. They know they're going to have to see Dick next year. This is not a mass tort litigation where you're trying to get into Presidio County, Texas, and get a big decision. So then you never have to go to Presidio County, Texas again. Okay? So that I think is something also, the nature of practicing water law, especially in a very litigious and judicially focused state like Colorado, you have these relationships, you're playing the long game, and I hope that's a way to increase the level at which you, law students, will practice law. So with that, I'll stop.
Thank you all. Appreciate it. One thing that I guess I'd like you to reflect on that sort of enters my mind on a regular basis is sort of the tension between, maybe it's that legal culture and the engineering culture, maybe not so much with respect to these big sort of state-sponsored investigations and state-supported modeling efforts, but more the garden variety, change of use cases, and single entity proponent kinds of water cases. How do you, on the one hand, you want to bring the best science and the best information forward, and maybe the most innovative information, and yet does the whole process that we have in this state maybe stifle that a little bit? In other words, I may want to pursue a certain line of investigation for my client, but it's going to put them in a position where he's burdened with carrying it through the water court for the first time, which will cost him more money, and reaching, I guess, the state of certainty that you want to have before you go into the courtroom will take a lot more resources. So I just want to ask about that tension between innovation and success in the water court.
Sure, I'll handle that one. Yeah, thank you. I guess first of all, there's obligation on the part of the testifying expert to present information that's defensible and that has good science behind it. The other reality is that we're all working with specific budgets, and there's a client, expert, and attorney relationship there that all need to communicate about what is feasible within a budget to meet certain project goals and objectives. There may be, obviously the owner or the client is going to have some sort of agenda that they're seeking, but there may be more than one way to get there. For example, a client may be interested in achieving one of these non-tributary claims that I was referring to, and it may be one of these situations where it's kind of on the borderline. I may look at it and say, yeah, maybe that's non-tributary, and we can give a shot at it and see if we can defend that in court based on information that's available. Or we would probably be safer and better off taking a path where we just go ahead and file a water rights augmentation plan, because we may not be able to defend a non-tributary claim for that particular case. So I think that there's always the need for communication, making sure that you're setting proper expectations for attorneys and for owners so that they're informed when you go through the next part of the court process, and they're informed about realistic outcomes. I think that's one of the obligations that we have as technical people.
Maybe I'd like to just add to what Chris was saying about, as you know, in Colorado, we've got a unique system. We've got obviously the Division of Water Resources, which is the administrative agent, but we have the water court system as well, that came about in 1969. Of course, water rights were filed in the district courts prior to that, and so the granting of those changes the water rights. And that's arguably been, from some people's perspective, saying it's a system that's been set up that creates a high degree of transactional cost, takes a long time to get things through water courts. So certainly I think a lot of the folks that have been in this process a long time and have recognized that, and certainly with the vision of Justice Hobbs back in 2007, created this water court committee that was set up by the Colorado Supreme Court to look at how we could look at changes in whether it's legislation, water court rules, or administrative processes to reduce these transactional costs when folks are going in, whether they're making these non-tributary claims or changes of water rights or just applications for water rights to begin with. And I think there's been a lot of headway made in that process through that committee, and looking at, for one example, the changes in the water court rules and developing these expert meetings where if there's a case before the water court, the experts of the parties can get together without the attorneys in the room and can try to work through and resolve the technical issues. And I think that's, again, there's some folks that agree whether that's been, helped or hurt and so forth, but I think it's a recognition that Colorado's tried to stay ahead in the forefront of trying to look at ways to reduce those transactional costs. I know from our administrative agency's perspective, wherever we've got authority over an administrative process, an approval process, whether it's granting a permit application, approval of a substitute water supply plan, we encourage those applicants to come in, talk to us ahead of time, try to address any of these potential concerns that are going to be there before they officially submit that, and it gets into a public comment and process, and where there could be objections or everything raised. And I think that's helpful. It obviously takes an investment of time up front, but it's a recognition. The earlier we do that collaboration and cooperation, it kind of avoids getting into this very conflict-rich environment where people become polarized and then they don't want to talk. Everything's communicated through email through our attorneys now, and all of a sudden it becomes very impersonal. So I think I know we're use technology to a great extent this day and age, but sometimes we've got to throw our computers and the cell phones out of the room and just sit in a room like this and talk about these complex matters, and I think we make a lot more progress. Burke, you want anything to that?
Just briefly, we don't have nearly the case law and the structure in Kansas that you do in Colorado, but I know that in the modeling context, one of the things that David Barfield is chief engineer in some pretty big water conflicts right now. One involves a national wildlife refuge, the Quivira National Wildlife Refuge, which is near Cheyenne Bottoms that Professor Peck discussed. There's an imbalance in who's got the modeling power. The state has more modeling power, but there's a groundwater management district that also has a model. One of the things in the administrative context I think that David has done a very good job of is trying to be as transparent as possible in terms of what the model is saying and what the model is showing about the impact of groundwater pumping on this refuge. So I think, again, it's a transparency issue. To the extent you can do that, the more things become a contested judicial fight, then your transparency is going to go away. But if you can, at the administrative level, keep it open, that is an important part of these highly technical issues.
I guess I would add to that, the state sort of took ownership of shoring up the water data back in the 90s when they started the Colorado Decision Support System, and sort of marshaling all of the different sources of data that are available and putting them into Hydrobase, and I think upping the game as far as doing diversion record analysis or record keeping and so forth has helped in creating better information and better science as well. So, others have questions? Can we take something from the floor here?
Headache at this point in the conference. So, when I learned prior appropriation, to get a permit, you need two things. Diversion, you got to show beneficial use. And Colorado is unique from all the other western states, from my understanding, is that they have, in addition to an administrative regulatory regime over water rights, they have a water rights court. And I'm just starting to get my feet wet, so to speak, in this unique Colorado water regime. My question is, how administratively does the state of Colorado regulate beneficial use? Who determines that legal term of art that grants private property owners their right to use water?
I'll take a first shot at that. A lot of that is defined in state statute in terms of what constitutes beneficial use. To the extent there's not been clear direction state statutes, we've had a number of court cases and all the way up to the Colorado Supreme Court. There was even a recent case in St. Jude's case about whether certain types of uses were beneficial use or not. And so, but principally that's where it's driven. The water courts are the ones who grant the water rights. Our agency then administers those. We have to ensure they comply with their decrees. They have to put it to beneficial use. It has to be non-speculative, and they have to do it without waste. And as long as they do that, we're within that control in terms of that administration. But any of those disputes in terms of whether we're not administering that decree properly are taken to the court to get resolved. So that's, I guess, just maybe a broad overview of how that is handled in Colorado.
You can ignore the question if you want. Let's talk Arizona. Let's talk about groundwater modeling and the fact that we've been in litigation down there for 30 years to the Supreme Court 3 times. How do we avoid this modeling gridlock? I mean, there's been so many models thrown out in the San Pedro. Give me some hope.
You schedule your retirement, and mine's in about 84 days. It's a great question, and I think Burke touched on this a little bit about when you get all the appropriate stakeholders at the table who have a vested interest in the outcome of what you're dealing with there, including the federal government, developing that, sitting down early on, working through that in a collaborative way, as opposed to, like you mentioned, in the Arkansas River Basin that I spent 24 years of my career. First, believe it or not, working for the state of Kansas in that case. But where you don't have those models and you're trying to develop the models under the threat or as a result of active litigation, it causes people to become more polarized. They're obviously trying to protect their positions, and they're not talking about really what the common interests are everybody has an interest in protecting that resource, making it sustainable, making sure it's equitably distributed or allocated. And so that's why I was trying to advocate and say that to the extent you can do that early on and develop those things in a more collaborative, cooperative way, and trying to avoid doing that through litigation, I think you're going to minimize the time involved. Although I've seen certainly in even these cases, we've been recently involved in interstate litigation, like the Arkansas River one took 24 years, but the recent ones in the Republican River Basin, some of the other ones that Burke and others have mentioned, they're getting done in like 2 to 3 years. I think that's part of driven by the U.S. Supreme Court saying these things aren't going to last that many years. You're going to get right to it. And the special masters that are assigned, like Special Master Kayada was just really worked through that. But the problem with that is sometimes when it takes a lot of time to develop good, robust models that are data intensive, they sometimes take a lot of additional data collection, and you're trying to compress that into a very short time frame as a result of litigation. I'm sure David Barfield will mention this too in our discussions. That even though we got a model out of the Republican River lawsuit that we continue to use today, I think all the states involved desire that there's probably areas within that model we can develop and make better. But we should do that in a cooperative way, not in a litigation mode where we've got to figure that out in 1 or 2 years. So I know it's difficult to say after the horse is out of the barn, you're in this litigation mode to get people back together to try to work in a cooperative way. But certainly I've seen more success approaching it in that fashion.
I think one of the reasons, first of all, there's a great law review article title, The Adjudication That Ate Arizona Water Law. It's about the Gila. One of the reasons that's such a mess is Arizona groundwater rights are such a mess, right? I mean, Governor Babbitt did create the Arizona Groundwater Management Act, which is seen as a real leader. But that's about groundwater management. Okay, the California Sustainable Groundwater Management Act, 2014. California, sort of leapfrogged other states in trying to get to sustainable yield in groundwater basins. But it expressly did not, and then you can see the part of the statute says, this act says nothing about established groundwater rights in California. They knew that that would be a political suicide note if they tried to actually describe the property right in groundwater. So I think one of the problems here is, in a place like Arizona and California, where you have inchoate, strange common law doctrines on groundwater, it makes the problem a lot more complicated. Kansas and Colorado in a lot of these situations have had more common ground because jurisdictionally they follow the prior appropriation doctrine for both surface and groundwater. Nebraska has been more difficult because they follow the riparian doctrine for groundwater, and there's no centralized state jurisdiction for groundwater there. So I think Arizona and California are tough because the groundwater modeling may help you get to a management point, but it doesn't necessarily give you clarity on the property rights side. So I'm just making your problem worse. I don't think but it's not just the science, it's also the way the property right speaks to the science.
I would just add to that, and like the previous comment I made, and again, it's coming from an engineering or scientific perspective, to the extent the laws and rules have been put in place don't match reality of what's going on between the interaction between surface water and groundwater systems, ignoring the facts don't change it. And I think that conflict is always going to be there until people recognize we've got to make sure those management systems, the laws and everything are consistent with the reality of the systems that are out there. We're still seeing challenges in Colorado today in our interstate and intrastate conflicts because of some of the laws that were set up in the 60s, trying to recognize there was a separation between those two and they weren't connected. And in reality they are, and to the extent we continue to ignore that, there's always going to be that conflict out there. So
I think there was a question on this side of the room.
Yeah, I am not a law student, I'm a journalist, so the question I'm going to ask is probably a lot different than most of the people that ask in this room, but who develops these models, where does the money come from, and is there the same threat of suppression that we're seeing of climate science under the current administration?
It all depends. I mean, I think some of the larger regional models that, say for example, the Rio Grande Decision Support System model that Dick was referring to has a lot of state funding behind it, and I believe some local funding behind it as well, does it not? So it somewhat depends. There are state-funded models. There are also simply applicant-funded models that may be funded exclusively by a party seeking a new appropriation or something of the sort. But there's also collaborative approaches. I mean, in the Cherry Creek Basin in Colorado, I'm working with a handful of municipalities that are collectively developing a model to look at a regional water resource and optimization of that resource outside of that court environment. But it's the type of situation that through that collaborative effort and the collaborative funds through those municipalities could ultimately lead to a court filing. And hopefully, because of that long history of collaboration, it's not going to be as contentious once it gets into that court environment. Now, to address your question about the dismissal of those scientific findings and all, I'm optimistic that that won't happen, but that's, I think, going to be a function of the framework within which those modeling results are being used. If they're used to develop, say, water court decrees in the state of Colorado, I think they're pretty insulated from any sort of administrative change. I'll let other legal minds comment on that, but I mean, there's a greater question of framework and jurisdiction that could impact some of those issues.
I'd maybe just comment too, Chris had mentioned these kind of basin-wide, or in Colorado we've developed now in all the major river basins decision support systems, which because Meg had mentioned this about we're the repository of all this historical data that's gathered that's in our hydrobase. one of the challenges we had before is we'd gathered all this information, but we didn't make it readily available in an easy way to consultants like Chris and others to use. We've made a lot of progress in that and making that transparent, publicly available. And that's why these decision support systems have become valuable tools, not only us as administrators, but for decision makers, the legislature and others in planning, in a planning perspective. Colorado takes very seriously the threat of climate change, and has done a lot through the Colorado Water Conservation Board in terms of those efforts of how do we plan for a future with this uncertainty with climate change. These decision support systems, I think, are going to be foundational to helping us meet those future challenges and understanding what our systems are going to do and how they're going to react to these changing conditions. And so, again, we're all, and we talked about this early on, the panel's talking about the threat of the reduction, whether it's policy perspective or funding from a federal level to support some of these programs. Colorado's certainly done a lot to fund these programs, but there's continued challenges out there with their own budget, and at least at this point, there's been maybe some limited impact to funding of those efforts, but hopefully that they don't take that completely away, because that would, I think, really undermine our ability to move forward.
Back of the room.
Our efforts to affect outcomes through the limitation of the scope of your inquiry as engineers, a problem generally? And if so, how is the profession dealing with that?
Efforts by who?
Client.
No, I mean, if there's a client limitation, usually that's going to be budgetary. And putting together groundwater models, for example, can be very expensive if you do it quote unquote right. It may require a lot of field investigation, drilling wells, which in some cases can be very expensive. And the solution to that is to do our best and to make conservative assumptions when it matters most. For example, it's important to understand what's important. What part of this model is a sensitive and important input, and is the assumption or the input that I'm using for that uncertainty a reasonably conservative value that's not going to result in injury to some other water user. If you take a reasonably conservative approach like that, I think there's much more latitude to move forward through a modeling and court process in a way that does not result in injury to others and to raise a lot of flags and cause concerns in the adjudication process.
Chris, is it always completely obvious what the conservative decision or selection of parameters is? It sort of depends on what the issues are.
No, it does depend on what the issues are. For example, in the world of modeling, if you're dealing with a lagged pumping issue, you might use a parameter that accelerates or slows down a depletion, and depending on what you use there, it's going to injure one party but not another. So there's a balancing act, and I think that's part of what needs to be considered. I mean, if you're considering some of these what-if scenarios, you need to think about that stuff. But usually there are pretty subtle changes. The non-tributary example is probably the one where it's a fixed line in the sand, and you're either on one side of that line or you're on the other. But other than that, it's usually a question of, well, does 90% of your depletion occur in 30 days or does it occur in 45 days? How meaningful is that? Sometimes it's more meaningful than another, but those are the parameters I think that you need to consider and be aware of when you go through those processes.
Back to the room.
So from various points that have been made, one could gather the possibility that what you're describing is moves towards a mediation model through the back door. And I wonder, has anybody thought about moving towards a mediation model through the front door? And if so, what does that look and act like in Colorado particularly, but anywhere for that In other words, if you've got transaction costs problems in your court system, and it's clear that there are, and you have judges trying to push through that by examining experts together, that's in a way that takes litigation out of the picture to some extent, takes cross-examination out of the picture. That's a move towards mediation. And I wonder whether mediation front and center would help to reconcile these cases better, and whether anybody's got that on their mind.
Well, under the Republican River Compact's final settlement stipulation, which is neither final nor a settlement nor a stipulation, now that the court has spoken on it, we have to do non-binding arbitration before we take an issue to the court. And how many of those non-binding arbitrations have resolved the issue, Dick? Yeah, he said 0. There's a happy story on the Platte, though, if you're familiar with the Platte River Recovery Implementation Program. This is an endangered species-driven situation where Nebraska, Wyoming, and Colorado all recognize that it would be much more efficient to try and figure out how to maintain in-stream flows for plover and sturgeon and other endangered species, rather than try and get some sort of legal decision that would harm one state or the other. They took it from a basin-wide standpoint. They used, I think, an existing co-heist model, am I right? Did they adapt it, or did they generate their own model on that? Do you remember, Dick? Okay. So there was a front door model building that I think is a great counterpoint to some of the other litigation we've seen in the West.
I'd like to maybe just comment on that, two things. One, tie in again to the efforts that Colorado's doing in a proactive way, developing these decision support systems that are not only surface water models, but in some basins, surface water and groundwater. Those have been typically done for planning type model purposes. The Rio Grande Decision Support System, the Republican River groundwater model have been used a lot for administrative type purposes. Again, not that they haven't been without some controversy and disputes. They have been trying to be developed in more of that proactive way. I know one of the things, and I think it's maybe on point to a little bit of your question, certainly in the last year or so, the Colorado courts, particularly the Water Division 1 out of the South Platte Basin, has utilized the alternative dispute resolution authority that they've had. And I know Justice Hobbs has been a mediator in those a number of court cases. It's been used to some extent in the Arkansas River Basin, kind of in a unique way in a dispute on a enforcement we were doing on a dam safety to breach a dam. But I think that's being implemented more now. Certainly Judge Hartman is utilizing that in a number of cases, and it's resulting in not all cases. I think there was one that I know that didn't end up in resolving the dispute and avoiding trial, but I think it's having some success in that mediation process.
You mentioned earlier old laws which were based on previous science and now maybe aren't completely current. And I'm wondering from what you think legislatures could do to ensure the use of sound science, because from a legislative viewpoint you might have a problem going on and you couldn't study it for 10 years and kind of develop the science behind it, but if you think there's harm occurring now, you want to do something about it. And maybe the answer is more delegation to administrative agencies that are more flexible and can kind of incorporate the most current science. And I'm from California. In California, that's certainly something the legislature could do because they can have faith that a new governor's administration is not going to be that different in terms of science. But actually, for example, that's certainly not the case. So I do have a specific example.
And that's a great question. I think one of the things we find is reality, not only in Colorado, but California and what they saw because of the drought. We're reacting out of a crisis mode. Colorado experienced that in the 50s. Severe drought, started drilling wells without really any regulation in place. And the regulations came afterwards, but you're oftentimes coming in trying to put a regulatory system into something that's very active and ongoing, and so you're trying to get your arms around something. From an ideal perspective, you'd want to develop, have the time, do that science and study, like you go to design this building, you do all that work, you build it, and there you have it. But you know, some of the laws, the groundwater laws we've had in place, whether we're dealing with the designated groundwater basins and what we're seeing as a result of those conflicts today, the challenges we have is particularly is where there's been a lot of decrees entered through the water court that have now, you know, put in place these plans, these augmentation plans and those kind of things. You know, unless people go back and change those decrees, which they oftentimes won't, because there's always a give and take in those settlements, in those cases, you've kind of now got what you got to live with those existing decrees. They're res judicata. You can't change them. But I think there's still opportunities as we go forward dealing with some of these future things as we continue to develop in these resources. Chris talked a lot about the non-tributary claims that have come about in the state due to oil and gas development and other things. I think there is an opportunity to really get those things worked out and good science in place. We developed some rules back in 2009 and 10 for the produced water out of these oil and gas wells, which I think is helping us move forward, and now we've got a certainty in place for that regulations to go forward. But it's a challenge because oftentimes we're always just in this reactionary mode after something seems to be in a crisis mode before we try to fix it. But I think certainly where climate change is one of the big challenges I see coming in the future, I think we can do things today in making sure we've got some sound laws and regulations in place to deal with that moving forward.
And just briefly, the only expansion I'll provide to that is that the questions that we're asking with these scientific tools are very much on a case-by-case basis. And I think it's hard for any sort of regulatory blanket to be put over the actual science. But what the legislature can do and has done, I think, for us very effectively is to give us the tools and the data to help advance that process. The decision support systems are an excellent example of that, where state government has stepped in and provided some very helpful tools to enable science.
Well, we're at the end of our hour and 10 minutes, and I would like to ask Justice Hobbs to come forward, and he's got an award to offer.
Thanks for the panel.
Yes, thank you very much.